Hi, everybody. My name is Rick Hills. I teach at NYU, New York University, NYU Law School. Right now I'm in Shanghai. I'm teaching at NYU Shanghai, and I'm very pleased to be here today to moderate for Shitong, professor of law at Duke University, and my go-to authority on all things relating to China, property, local government, and in general, the concept of neighborhood, municipal, and regime rule over land. So I'm very delighted about our presentation today and looking forward to listening and asking questions. Before we get to that, I just want to note that US Alley has two great presentations coming up. One on February 24th at 1:30, Professor Kanehara will discuss Japanese role in international security. And Professor Wei Cui, who's visiting at NYU Law School and is an expert on, among other things, Chinese taxation, administrative law, will discuss administrative foundations of the Chinese fiscal state. On February 28th at 7:30 in the evening. So I'm really looking forward to those two events, and I hope as many of you as possible can come and attend those two. In the meantime, Shitong, it's great to see you. I love this paper. As you know, I've read it in draft, and I know that an earlier version was called Not Finance Against Law, but Finance Without Law, echoing Bob Ellickson's famous book, Order Without Law. But upon contemplation, you realized you were saying something that actually much more radical. Could you say a little bit about what it means to have finance against law, extra legal or even illegal finance, and the challenges that poses for international financial institutions?
Sure, Rick. And firstly, thank you for the generous introduction, and also thanks Catherine and also US Alley for this opportunity. And also thanks everyone for coming to discuss this idea of finance against the law. So to answer Rick's question, right, why I decided to use the title "Finance Against the Law" instead of my previous title "Finance Without Law." I'd like to share a couple of slides, if you don't mind, Rick. We can start with the relationship between law and finance, right? Which is a very classic idea going back long, but around the 2000s, there are lots of lawyers and leading legal scholars and economists talk about the necessity of legal institutions, particularly independent courts that are functioning to enforce contracts and also to protect property rights. They believe that's essential to the development of what they call impersonal financial markets that are beyond transactions among people who know each other. This idea had not died. Just recently in 2020, right? One of the representative works in this trend is actually Columbia Law professor Katharina Pistol's idea, the book, The Code of Capital, which is law, right? So this idea is very much alive, that arguing that legal institutions are essential to the development of impersonal financial markets, which is very intuitive, right? Think about London, think about New York, right? These are all leading financial centers with well-functioning common law courts. So that's one part of the literature. The second one, going back to Rick's question, basically the idea of finance without law. What does that mean, right? Finance without law, there are a few examples we can think about. The cryptocurrency markets, right, which rely on decentralized technology to secure transactions. So they don't need judicial enforcement. Or you can think about sovereignty, the markets of sovereign bonds. That's another example of finance without law, right? Because you don't really have a court or a judicial institution that are well equipped to enforce contracts against sovereign states. There are also studies of the global swaps markets, some studies about cross-border securitization, right? Those are also examples of finance without law. a classic study by a Berkeley economist is actually is a study about the early form of the shareholder company in the Roman Republic, like more than 2,000 years ago, right? Which was not regulated by law, right? But it's not against the law. In the China context, actually, Professor Xu Chenggang and Castellana Pistol, they have a very interesting paper published in 2005 talking about how China's stock market, right, around like late 1990s to early 2000s actually started and developed relatively well, at least compared to the Russian counterpart, right, without well-functioning Chinese courts. So these are all examples of finance where there are law in the sense that there is an absence of well-functioning courts to enforce contracts or to protect property rights. But all these transactions, generally speaking, right, you can talk about cryptocurrency markets, but generally speaking, they are not against the law, right? Those are legal obligations that everybody recognizes. It's just that either the courts are absent or that the courts in China in early 2000s are not capable of enforcing contracts. So they are not against the law. What I mean, finance against the law, you can think about, I mean, there are two subcategories. First one is I call private finance against the law. You can think about, for example, underground finance of criminal organizations, mafias, right, using diamonds. You can also think about in the Chinese context, actually many scholars have written about the so-called illegal crowdfunding, right, or illegal fundraising, 非法集资, right? Basically, Chinese entrepreneurs back to early 2000s, I think it's still present today, right? They had limited access to state-owned banks. So how do they fund their operations? Many studies by scholars basically said, oh, these entrepreneurs, they have their own ways of raising funding, right? Basically, they are issuing loans and also pay for loans with interest much higher than the interest that's allowed by the government. So lots of studies about this, right? But I don't want to focus on private finance against the law. Why? Or even finance without law. Why? Because I'm primarily interested in the relationship between, again, law and finance, right? The logic is that either you have legal institutions, courts, right, that can enforce contracts, can protect property rights. That's going to enable impersonal transactions among people who don't know one another, right? Or you have transactions among people who know each other, right? Again, right, underground finance of criminal organizations or communities of Chinese entrepreneurs. So in that sense, right, although some of the research, like this article by Frank Allen, right, 2005, Law and Finance in China, they believe that the private finance, right, against the law actually challenges the mainstream law and finance theory, and it's very popular, very frequently cited, several thousand times. But I don't believe their article really challenges the law and finance theory, because the private finance against the law is still a market of members of close-knit communities, right? Basically entrepreneurs who know one another. So if you want to successfully challenge this mainstream, still very much alive theory of law and finance, you have to tell them that actually without law or even against the law, there is an impersonal market, a market among hundreds of millions of people, right? People who don't know one another. So that's why I want to focus on what I call the public or state-engineered finance against the law. Before I talk about my case, I would say another example, probably the other example, another major example I can think about, but which unfortunately I don't have much expertise, is the Islamic banking system, which control assets of near $4 trillion and operates with various mechanisms to circumvent the Sharia law's prohibition on interest. I think that would be another nice example of state of finance against the law, right? So With that background, I hope I have explained what finance against the law means, right? And why it is different, right, from other studies that have already existed. I guess many people come here not necessarily because they're interested in theory, but because they're interested in this I would call a $1 trillion question, right? I have two examples. One is the VIE market in China, VIE market, right, used by China concept stocks. The other is the Chinese issued international bonds, right? So the first one is the equity market. The second one is the debt market. Both of them has a total capital of several $1 trillion. So I'll focus on the VIE because I think that's more familiar to the audience, okay? But the logic applies to the Chinese issued international bonds also. Firstly is a $1 trillion question, right? Just to give you some idea, right, for people who don't know about this phenomenon, right? Basically, all the Chinese internet companies you know, Alibaba, Tencent, they have all adopted the so-called VIE structure, which I'll explain in 1 minute what it is, right? To get listed in the US, right? And the size of the market, right? And also the duration, basically it's the same size of the NASDAQ, Nordic, and the Baltics, right? And also about the same size of the Deutsche stock market. So it's quite remarkable if you do this kind of very rough comparison, right? Lasting for 20 years, right? With such big size. But the interesting part, of course, right? Against the law and finance theory, this market is against the law. It's against the law, right? What does that mean? I just tell you this story of Jinah, which basically started the era of China concept stocks, and also in the process of getting listed in the US, right? The form of VIE was created. The story is pretty simple, right? Basically, Jinah wanted to get listed in the US back to 1999, 2000, right? And all the international law firms, financial intermediaries all got involved. Everything was almost ready, but then the Ministry of Information and Industry Technology, right? 信息产业部, right? Basically told Shitong that, oh, you cannot get listed in the US because actually we don't allow foreign capital in the industry, right? But of course, the MIIT, the ministry, also understands that foreign capital access to the international capital market is also essential to the success of Jinah. So the founder of Jinah persuaded officials of the MIIT that, right, we need access to international capital market to succeed. And the Chinese government wanted the internet industry to succeed. That's one part of the equation. Right? On the other hand, right, Chinese government was worried that, right, it might lose control of the internet industry, right, which was a mainstream news website to foreign capital. So there's a balancing, there's trade-off there, right? So how to do this? And of course, there's this clear legal prohibition there, right, saying that no, there should be the negative list, right? There should be no foreign capital in certain industries. So how to do that? I found the story really interesting from both the practical and also theoretical perspective. Eventually, there were like a lot of negotiations between MIIT and Jinah. And they figured out a plan together, which is VIE. Basically, the story is that, okay, Jinah, a Chinese company, right? You cannot be controlled by foreign capital. But, right, the overseas version of Jinah, right? Jinah Hong Kong, Jinah Taiwan, Jinah US, right? They can get listed in the US. That's not a problem at all, right? So what they do is that the VIE, basically the Chinese entity, right, signs contracts, various kinds of contracts with the OFO, the wholly foreign owned entity, right? Owned by basically the overseas version, right? The Jinah Taiwan, Jinah Hong Kong, Jinah US, right? Right. So basically to control, so the listed company, right? Company listed in the US controls the Chinese entity, not through equity, not as a shareholder, right? But through a series of contract arrangements. And eventually it's the cliche, right? It's a win-win, right? It's a win for the government, basically saying that, oh, Xinjiang didn't really get listed in the US, at least the Chinese entity, right? It's also a win for Xinjiang because Xinjiang actually now got access to the international capital market. So that's the idea of VIE. I mean, the legal details are much more complicated, but just to remember, it's basically one company, two names, all right, roughly speaking. So that's the legal trick. And then you have all sorts of risks, right? And also huge debate about the legality of such arrangements, and the different scholars, different authorities in the US and in China have, different stances on this. For interest of time, I won't talk about it in detail, but clearly there are two risks, right? Legal scholars and economists are mostly concerned about. Firstly, right, what really connects the Chinese operation, right, hundreds of billions of dollars operation, right, and the shareholders in the US are these contracts, right? So then the question clearly is whether such contracts are enforceable, right? And secondly, because such contract arrangements have circumvented regulatory legal prohibitions, right? And potentially there could be regulatory enforcement against such arrangements, right? So what are you going to do, right? As participants on the market to minimize, right, or to control such risks, right? The contract risks and also the risks of your investment. And before answering that, just to be clear, your concern is very much legitimate. Although I would say 20 years ago, nobody seemed to be concerned, and today is the opposite, right? Everybody is concerned. But in the history, right, I think it's what really shocked the market, I think at the beginning, was really in 2011. So Jackie Ma terminated the VIE arrangements, the contracts, right, connecting the Chinese entity with the overseas listed company, right? And he said because Chinese government doesn't allow foreign entities to have a internet finance license, right? So that shocked the market. Everybody suddenly recognized that, there was a problem of judicial enforceability, and Jackie Ma can unilaterally revoke those contracts, right? So there is such a risk, right? A risk. And there was also risks of regulatory enforcement against such arrangements, right? The most famous is really just the Buddha Steel case. If you're interested, I can talk about that later in Q&A. The $1 trillion question is basically how this market operates, right? Against the law. Again, think about theory. The theory is that either you have judicial enforcement, right? It has to be law-based finance, or the other theory is that like a study on the market of sovereign bonds would be, right? It's close-knit communities, right? A community where people know one another. My theory is a little bit different, right? I actually borrowed a little bit from the studies on relational contracts, but which have not been applied to the financial area. The idea is that you don't really, the two theories is either impersonal transactions have to be based on law, or transactions among people who know each other, right? Close-knit communities. I think those two theories are too extreme. You have something in between. The idea is that we should understand market participants as in the network. They are not necessarily in the same community, like a close-knit community, right? Like a village where everybody knows one another. It's a network that not everybody knows one another, but it's a network with what network theory would call supernodes, right? Like the people here, the players here, right? Who are centrally placed in this network. And these supernodes, they know one another, and they constitute a close-knit community among themselves, right? So these supernodes, they help check information, monitor information flow, and help the flow of the information, right? Eventually, right, this network can operate, right, relies on two things. Firstly, it's basically reputation, right? The reputation of the supernodes, and also they can hold other participants, right, accountable by reputation because they know other people in their local network. So the requirements are simply information has to be accurate, and there has to be a rapid flow of information. And secondly, people care about their reputation. And that's why earlier literature says, oh, it has to be a close-knit community, because only in the close-knit communities with long and repeated interactions, people care about their reputation. But now I say in the network with the supernodes, right? Supernodes care about their reputation, right? They can hold one another accountable because they constitute a close-knit community. And all these supernodes, right, in part of the network, that also constitute close-knit communities, right? So that ensures the rapid flow of information across the entire network, although the entire network itself is not a close-knit community. So that's the idea. Reputation, accuracy of information, and the flow of information actually can enforce contracts and protect investment, right? I have lots of details in the paper, but basically based on the actions and the inactions of state regulatory agencies, statements by political leaders, right? And also various contract designs by intermediaries, right? It's not hard to understand why reputation can work and also why accurate information is actually flowing across the network. Just for interest of time, one example is that after the Jack Ma case, Alibaba case, right? Basically, Wang Qishan made a statement, I mean, informal statement, but everybody got to know is that, oh, we should respect the history, right? And the VIE made such a huge contribution to China's internet industry, right? We should maintain its stability, etc. Right? Intermediaries, just for right, I collected data about all the underwriters and also law firms. It turns out that it's only a few or a dozen, right, that basically monopolize the entire market, right? For example, the representations of U.S. law, right, for all these IPOs actually Skydon, right? 63 out of 173 IPOs, 63 are done by Skydon, right? And the industry-specific communities, these internet companies, they share again law firms, underwriters, and even management talents, right? For example, Chen Wei, one of the founders of Didi, actually worked as a senior manager in Alibaba, right? So within such an environment, it's not hard to understand. Again, reputation can flow and is accurate, right? And information can flow and is accurate, and the reputation matters. So the Jack Ma case, again, is always given as an example to show the fragility, right, of the VIE contract arrangement. But actually, if you read it in detail, I would say arguably, you can read it actually as efficient bridge. It's not a story that Jack Ma walking away from the contracts without any consequences. He actually paid a lot, right? I mean, you can have a debate about how much, right? Whether it's enough, but he paid a lot for revoking that contract. So there are remedies. And what he did also was immediately and severely criticized by both his peer entrepreneurs and regulators. For me, that's an evidence that reputation is at work. I won't talk about Chinese issued international bonds, but just to conclude, right? The VIE market nowadays with lots of controversies, but we are all focusing on the controversies. But if you look at the entire market, I would say there are, until today, very few contract defaults and also very few regulatory enforcement. For the contract default, I counted all reported cases, 5, maybe more, you tell me, but it's not that much, right? But so the VIE maybe is not an optimal solution about how China has built up an internet industry, right, with the help of international capital market, but it's the second best or even third best solution, right? So implications quickly. Firstly, I would say law and finance scholars are right that in-person finance needs the backing of the state, but they are wrong to assume that the state can only back in-person finance with legal institutions. Right? The state can do it with reputational mechanisms, right? And the state itself is an impersonal institution, right? And second one, I would say, kind of going back to the idea of order without law, I think a gap in the literature on order without law or private ordering is that scholars generally have focused on private ordering. And my research really sheds light on the role of the state and the politics in actual legality, right? It's state engineered actual legality. I think that's something new. And the last one, right? Law and finance scholars talk about how essential law is to the development of in-person market. They're probably right, but I think they got it wrong. The real problem for developing countries interested in financial development is legal barriers and incumbent interests. It's not just the absence of the ideal independent courts, right? So in the broader context, I think what this Chinese study has pointed out is really an approach of actual legal development. So you can think about actually in the Brazilian practice, the so-called institutional bypass, and also the Japanese practice of bucking the system. I think this is something law and development scholars have not paid sufficient attention to. So I'll conclude here, and thanks again. And look forward to your questions and discussions.
Well, Shitong, that was absolutely terrific. Thank you so much. I want to get the question started with just this idea of an impersonal market with personal supernodes. So this is kind of a mix, right? We have millions of investors who don't know each other, don't love each other. They're not the mafia. They're not a close-knit group of Jewish diamond merchants. You know, so it's not like they say, hey, if you break this contract, I'm going to make sure you're not invited to Thanksgiving. But at the same time, with this impersonal network is held together by personal reputations. And I guess I wanted to ask you, what's the relationship between the stability of finance against law and its reliance on these personal figures? I mean, the example I read in the paper that I thought was interesting is, look, you know, these supernodes include people like Hank Paulson or a Morgan Stanley figure, or Wang Qishan over at, you know, MIIT, or in some important position in the Chinese state. And also like these big, well-known entrepreneurs at Didi or Tencent. Well, those guys aren't very stable necessarily. You know, I feel like we should just invoke the case of Baofan, right? Yeah. They could be disappeared. Wang Qishan is on the out right now. I mean, I don't know where Wang Qishan is, but he ain't in the seats of power anymore. He hasn't been disappeared, but a lot of his, you know, followers have. So yeah, in some sense, could you say a little bit about whether this kind of situation, the system is stable? And I have some follow-ups to that, but what do you have to say about that?
Yeah, great question. I just want to clarify here that the supernodes include not only individual politicians, individual you know, prominent members of the international financial intermediaries, or individual entrepreneurs, right? Every individual, right? They come and go, right? But of course, each individual also has a reputation. These people, right? They are also, I would say, in a relatively long time horizon, long-term and also repeated players. But I think what makes this market stable, firstly, I do think these individuals contribute to the stability of this market. But secondly, I think more importantly, what contributes to the stability of this market, you know, against the law, right? It's the various state regulatory agencies, right? And also the Chinese state itself has an interest in preserving the stability of the market. So that's why I say the state reputation, not only just the individual politicians, that matters. Because again, I talked about in my right, there is a balancing of the interest of the state to basically to development, right? Could it be developing the internet industry, to develop the economy, right? For example, right? That requires actually access to the international financial market, whether it's stock markets or like in the other study I did, right? The international Chinese issued international bonds, they needed access to the international capital market. That's very much essential to the Chinese state. So yeah, therefore, the Chinese state cares about its reputation, and therefore, to not only not only itself not to do anything that's going to destabilize the market, and also to make sure that private enterprises, right, not to destabilize the market. So that's, I think, something important to keep in mind. But second one, I do want to make a connection between the state as an actor and the individual politicians. Because my critique of the law and finance literature is that they have not talked much about the incentives of the state, right? So I've talked about the incentive of the state. But state is an entity, is a long-term repeated player, has a reputation there, but is an entity, is a legal fiction, right? In a sense, the state. So you need interest groups within the state to kind of hold the state accountable, to hold the state to honor its commitments. In my paper, I talk about that basically any reform or any development, right? A challenge is that you have incumbent interests, right? Players who don't like the idea of creating a new market, right? Could it be a new internet industry, right? Access to international market? Could it be in the Chinese context, for example, the market economy or the creation of the special economic zones, right, in Shenzhen? So the challenge of development is how to do that, right? Is how to do that. So you need politicians or elites within the regime to basically to advocate, right, for such reforms. So that's why I say that's why actually the role played by politicians are also important, right? Could it be individuals, but could it be just this faction or group of political and business elites that they are vested, right? Their career, their fortune relies on China to be successful, right? In economic development, in opening up to the outside world. So I think that's the second point about basically the stability of the market. Why both individuals, right, but also as a group of business and the political elites, they matter, but also the state as an entity itself also matters. So both of them contribute to the stability of the market.
So let me push you on that, because I see questions in the Q&A that go directly to this point. Mm-hmm. So one person says, well, what role do relationships with Communist Party officials play in this market? And the relationships may be corrupt, or they may simply be, you know, somebody like Wang Qishan saying, look, we can't make our system work if we cut ourselves off from the world. Mm-hmm. But to a certain extent, I think that question runs parallel to a question I had, which is, are these institutional supports that you mentioned really just a shorthand for relationships with particular officials? And I take you to be saying, no, it's more than that, because individual officials like Wang Qishan come and go. It's more like a general interest of lots of officials within the state. And so another question, which is related to this question that I want to push you on about the relationship between the personal and the institutional, the transitory personal and the more permanent institutional, is if the state's so strongly dependent upon the stability of these arrangements, if there's just lots of people, say, in the Ministry of Information and Industry and Trade that say, look, we got to make this work. And their memos get shunted up so they eventually land on Xi Jinping's table. And Xi Jinping says, hell, fine, I'm going to back off on hitting the tech companies hard. If the state's so strongly dependent on this stability, how does the political imperative of maintaining these arrangements differ from law? What is the relationship between the general interest of making sure that China's tech sector does okay and the idea of law? And what's the relationship of these interests and particular individuals?
Great. So first, I just want to say, we need to see probably a bit more about the current state situation, right, in China. Basically, what I say is the trade-off or the balancing between development and control is kind of it's kind of shifting, right? Shifting towards like a more emphasis on control. I do think that has an impact on the stability of the market, but that's something we can talk about later. But talk about your question, right? Whether it's just about corruption, right? About just individual like relationships with the Communist Party. I don't think so. Again, think about reform, think about development. What do you need, right? Back then is that, well, think about where this, what I call governing by actual legality, why, how, like when and why it was created. Basically, there was a stalemate, right? You have one group, I mean, to put it in a probably oversimplified way, you have one group that says we need economic development, and to do that, we need access to international market. Right? You need another group that says, okay, we don't care, but our primary focus is the stability of the country, is basically the Communist Party's control over the country, right? We cannot lose the leadership of the party over the country, right? So those are two goals or fundamental governance goals of the party, which are in tension with one another, right? I mean, the argument made by the reform faction is that, you know, if we can develop economy, the country is going to become stronger and the party's leadership is going to be consolidated. Basically, each party has its own argument. No party can persuade the other. And in that kind of stalemate, right, you cannot reform the law because status quo is preserved. So what the reform faction is doing, basically, just like what they did with special economic zone, is that they just went ahead, right, without legal authorization, and that was kind of acquiescent by the state, right? The idea is that, well, let it go try, right? If it succeeded, and we at least, you know, if since it's kind of actually legal, if there was like any bigger risk involved, right, bigger incidents, we can also possibly shut it down. So that's the idea. So the idea of actual legal control is that since we have this kind of like this restriction of actual legality, right? We have never like formally authorized you to do it. So if there's any trouble, right, you are really in deep trouble. So so that actually kind of maintain a balance between control and development for the state. So in essence, again, I don't think this is individual relationship with individual officials, because again, for the party itself, China's party state, right, there's always a balancing of control and development, and in different eras, right? Some leaders emphasize more control than development. Some leaders emphasize more development than control. Maybe now we are in a stage of emphasizing more control than development. But overall, as far as the state still recognize, right, the necessity to development, and also to recognize that access to international market is essential to development. Then the market is stable. That comes back to your second question, is like, how is this stability, right, maintained by the basically, I would say, self-enforcing incentives of the state, right? How is it different from law, right? I think it's quite obvious that it's different from law, right? Firstly, yes, the law is not reformed, so there are still legal prohibitions. Although the CSRC, the Chinese Security Regulatory Commission, has been trying hard, right, to clarify the situation, to formalize it. But frankly speaking, exactly because of this tension between control and development, and also this unsettled or settled stalemate, right? Unsettled contest between different goals of the party, right? I don't think it can be formally settled by law, right? Unless China say, oh, we are just going to formally abolish all those bans or restrictions on foreign capital to different industries, right? But that's not going to come soon. So it's entirely different from law. It's actually it's in a sense naked politics, and without and cannot be resolved by law at this stage of development or this stage of transition, right? So that's the second question. I do think this political mechanism is against the law and is very much different from law. Last one, just going back to my first point, right? The stability of this market, again, relies on the Chinese state's regulation and the intent of that to maintain its access to the international capital market. If that's gone, right, the stability of the market can also be gone. I think that's what we are worried about right now.
Well, on that, I see more questions in the Q&A that are pressing you on this, and this would be a good opportunity to clarify. One question is, look, are these relational mechanisms, which are more impersonal than just Wang Qishan or some apex figure who could come and go, but more personal than simply courts impersonally enforcing the law? Are these relational mechanisms that in this twilight zone merely informal or extra institutional rather than being actually extra legal, or if we might just be blunt, illegal? Could you explain why they're illegal? You had a slide on that. This would be a good chance just to say, hey, this is not just simply informal or casual. This is illegal. I mean, let me give you, to sharpen this question, we have VPNs in China. VPNs are illegal. Let's just be clear about that. Don't have VPNs. And NYU Shanghai, by the way, has a licensed VPN. It's legal, but lots of people have illegal VPNs. And Beijing has a special zone to develop VPNs. So that's like an analogy in a way, something that is clearly illegal. And boy, does the mayor of Beijing want to encourage this illegal thing. So explain exactly the extra legality here.
Right. So it's institutional, right? It's institutional practice. We talk about not only just individual statements, right, by political leaders or by entrepreneurs. We talk about all these regulatory documents, right, issued by various regulatory authorities, right, in the past 20 years. And even just they are in action, because all these practices, VIEs, they are not hidden anywhere, right? And to get the capital inside China, you need cooperation from various regulatory authorities. So it is institutional practice. It's illegal or it's actually legal in a very technical sense. In the sense that, firstly, there is a negative list, right, of industry entry, like what industries foreign capital can go into, what industries they cannot, right? And some of these industries, right, like internet, right, back to 2000s, right, they were on the negative list, and foreign capital got in anyway through the VIE. So that's what it means, illegal or actually legal, right? And then Chinese contract law says clearly, right, contracts that have, lots of different articles in China's civil code, back in the general principles of civil law, basically to say contracts that have violated laws and administrative regulations, right, are void, right, or contracts that are designed to to conceal illegal purpose, right? Again, it's illegal purpose here, meaning to circumvent the constraints and also a ban on foreign capital in certain industries are void, right? So in the technical sense, right, they are actually legal or even just outright illegal. But of course, I'm sure there are lawyers in the audience who can debate about this, right? You can say, actually the contract law, Chinese law says only contracts that violate laws and administrative regulations, right, are void. And the contracts that violate only, for example, administrative measures are not void. Anyway, if you're a lawyer, if you're a Chinese lawyer, you know what I'm saying. When I'm talking about the hierarchy of the different layers of Chinese law. That's why all these law firms, right, the representations of Chinese law, right, for the IPOs, they all say that, these contracts are legal, right? We don't think it actually violates Chinese law in any sense. But in the meantime, they said, we cannot exclude the possibility that the Chinese authorities would make a contradictory interpretation in the future, right? So I would say, and the Chinese courts, right? I talk about various cases. I'm sure, again, there could be a great debate there, right? On one hand, you have the 2012 decision by the Supreme People's Court, right? The Minsen Yinhang case, right? Basically, the court said, oh, if the contract had concealed illegal purpose, right, the contract should be void. But of course, that decision is not about VIE specifically, but it worries the people who participate on the market because it's essentially a same logic applies to contracts of VIE. But then you have the 2016 Supreme People's Court decision says, oh, if a party, right, that was the party Ambo case, right, went to the Supreme People's Court, basically wanted to invalidate the contract, saying that, oh, the VIE contracts actually, should be invalidated because they violated the law, the Chinese ban foreign capital in industry, right? But the SPC basically said, oh, what you have referred to, right, was an administrative measure, not an administrative regulation or law. Therefore, we are not going to invalidate the contract. But pay attention here. It's not exactly the same as saying that we are going to confirm the legality of the contract. The court basically say, we don't want to invalidate the contract. It's not our business. We are going to defer to the related regulatory authorities to decide whether contracts are valid or not, right? It's the same thing as the CSRC's administrative measures promulgated just 3 days ago, right? It said, oh, we are going to register or allow the filing of the the IPOs through VIEs which have complied with regulations, right? But that's okay, right? Who is going to decide whether they have complied with the regulations? It's other regulatory authorities, not the CSRC itself. So, long story short, the question about actual legality, I think essentially is that the contracts of VIE are designed to circumvent Chinese ban or restricts on foreign capital in certain industries, right? And that poses the risks to contract enforcement and also poses risks to the security of investment. And that's real, regardless of how you define the legality of VIE. That's why I want to use the word actual legality, because I think it's broader than the term illegality, right? Because illegality would be just already illegal, but actual legality basically to say, there is a significant risk, right? But the people clearly, not only scholars, but different authorities, including Chinese judiciary, is kind of ambiguous, right? About the legality or illegality of the contract arrangements. So that's why I use the word actual legal.
So that's why my VPN analogy is not quite right, because it's clear that VPNs are illegal, where it's not 100% clear. I read the mishmash of these decisions, and equivocal language really does make extra legality seem like a good description. There's a good question in the chat that I wanted to point out just to broaden this discussion beyond China, and it connects to something I wanted to ask you. The question in the chat that I thought was great was, look, what lessons can other countries draw from China's financial system and regulatory approach? Other countries have emerging markets. Other countries have these tensions between control. We don't like foreigners controlling our business, but they also want market development.
Right.
Does China have lessons for them? That's one question. And another question, which is much less from me, is, are there analogies with the United States here? The one that comes to mind in my mind is immigration. So we have bans on immigration. By God, you better be documented before you get a job. We better have an I-9 form on you. We have strict bans against undocumented people working. And we have 11 million people here who are undocumented working. And also, although it's clear their presence is illegal, we have devices like, say, deferred action, the old DACA policy, which puts them closer to this extra legal rather than illegal area. So what if I hire somebody who doesn't have an I-9, but they have a DACA no action letter? What's my culpability? And that seems to bear an analogy here. We could also talk about marijuana enforcement. I'm not in New York City, but if I were, the smell of skunk weed would be all over Washington Square. And that's a controlled substance. That's a Schedule I controlled substance. It's illegal. It's not just extra legal. So could you say a little bit about analogies and lessons? Analogies and lessons.
It's easier to answer the U.S. question. I mean, U.S. believes in rule of law, right? But think about the 2008 financial crisis. Actually, this is from my Duke Law School colleagues, financial law experts, Arthur Elder. But I thought about it, but I got a confirmation from the leading financial law scholars, basically saying, "Oh, your understanding of this is right." Think about the Fannie Mae, right? The U.S. government, I think on their documents, according to him, it says that the U.S. government is not going to bail out. The U.S. government is not going to bail out, right? That's in their document. But eventually, when there's a financial crisis, the government bails out them anyway. So there's no legal obligation for the government to bail out. But the government bailed out anyway, and essentially for the same reason the Chinese government did, right? Because it's about the survival of the system. It's of systemic importance, of significance, right? In that sense, it's also, it might be, that's not a finance against the law, but that's at least finance without law at the system level, right? The government has no legal obligation, but is going to bail it out. And the Fannie Mae, right, these financial institutions, they relied on this actual legal commitment from the U.S. government anyway, right, in their daily operations. That's why economists are talking about the moral hazards all the time, right? I think that's a nice example. And Katharina Pistol, I think in her book, she recognized that. She said, "Oh, at the top of finance," right? She said she created this very idea about the elasticity of law. Basically, to say, "Oh, the law is flexible," right? It's like the higher in the hierarchy, the more flexible the law is. But I would just call it actual legal or against the law, right? So that's the U.S. example. Lessons for developing countries. I know it's not popular anymore. 10 years ago, maybe people would want to hear about, what China can teach about the world, right? Now it's totally the opposite attitude. I don't think it's about whether China can teach other countries, right? That's more like a kind of politically driven approach. I do think it's important for us to understand the past and the present of China's development, both its strengths and weakness, right? So that we can understand its future. But I do think, comparatively speaking, about other countries, there is a lesson to take, which is what I said earlier in my presentation, right? Law and finance, the theory goes that for financial markets to develop, right, you need well-functioning independent courts. So law is essential. I don't think a theory, right? But the problem again, for developing countries to create new markets, right? Lots of failures. Again, the main hurdle is bad law. We want a good law, but the other side of the story is bad law. Is all sorts of legal barriers and the incumbent interests, politicians who are defending, who are guarding such bad law, right? That's like the real world problem. And how to solve that? I do think the VIE market in the past 2 decades in China had pointed to an approach that what I call actual legal development. You just have to, right? Because in such countries at the beginning of development, you don't have sufficient capital, political capital to change the law instantly. You need to basically to grow an interest group to support the new practice. And how to do that? When you don't have sufficient political capital to grow an interest group, what you do is you do it in a slicky way, right? You circumvent the law and the regulation to do it step by step. And exactly, right, it's actually legal, right? Those incumbents, right? Those people who are defending the status quo, they don't really take you as a big threat. They thought, it doesn't really hurt that much if they want to try, right? It's stalemate anyway, right? If there was a threat, we can take actions. But you don't have the hindsight you would have later when market reform actually succeeded. So that's kind of the analogy I think made by Ronald Coase and Wang Lin in their book, How China Became Capitalist. I think that's a lesson, right, for development countries. So maybe actual legal development, I mean, the development that actually circumventing bad laws is not that a bad idea. To be sneaky, maybe not that a bad idea. I think that's, again, I talk about the Brazilian practice of institutional bypass, right? When you want to reform a market, you don't really reform the market. You create a new market besides the old market, right? When the new market grows up, the old market is gone. Or in the Japanese context, it's called barking the system, right? So I think there is, it's not necessarily a Chinese lesson. I think there are different countries. If we really do studies about, again, Japan, Brazil, I think in their process of development, they have figured out all sorts of ways of circumventing the legal barriers to move forward.
Well, and as I listen to you, do it in a sneaky way sounds like a great slogan. That could almost be a Chengyu, or I'm sure there is a Chengyu, do it in a sneaky way. But the big moral here seems to be, if you don't have the interest groups for a frontal assault on a bad law, then go around that bad law in a sneaky way. And maybe you can develop the interest groups later. That's kind of a clever idea. We've done that with marijuana in this country. There was no interest group capable of repealing marijuana status as a Schedule I controlled substance. But if you simply turned a blind eye, you would grow those interest groups pretty fast. Now it'd be almost impossible to return to the status quo where marijuana was a Schedule I controlled substance. But I was thinking, one of the lessons that you could give to the United States is now all these marijuana cannabis firms want finance and they have no banking. They're just carrying around gigantic sacks of money. And so they need a sneaky way to get finance. So maybe your next paper can be on pot in the United States, banking pot, I had this final question, and that is, you hear a lot today about the Chinese political scene as lacking factions. Bill Bishop will say, there ain't no factions. There's no CYL faction. It's all Xi Jinping all the time. But you are kind of pushing on that a little bit. You use in your paper the word faction. I think you mean the word interest. Could you say a little word about the difference between a genuine CYL, Communist Youth League faction, and an interest, which, a division between, say, development interest versus security and control interest. What's the difference there? We might have divided factions. We might not have divided factions anymore, but do we have divided interests that serve some of the same function?
I don't particularly like the idea of factions, but because I think that it focuses too much on individuals. Therefore, it's a much more fluid concept, right? And maybe less useful because, right, we basically, it's kind of like we said, right? So, but I focus on, I think, more fundamentally, the goals of governance of the Chinese state, right? Which I think is much more stable. When I say the Chinese state has at least two main goals, one is to develop the economy, which is very much related to its legitimacy. The second one is control, right? It's consolidating the party's leadership. I think those two goals, generally speaking, are quite stable, right? Because when you talk about factions, again, right, you have a new leader, right, who has consolidated power, you see the factions are gone. But when you talk about the growth of the state, development and control, I think those are there. We're running out of time, but I want to also take this opportunity to say that, again, going back to your question about the difference between politics and law. When I say law is unnecessary, I say the tactics of law, right? Whether it's legal or actually legal, and whether courts are functioning or not. I mean, those are important, but I think they are much, much less important than a regime's commitment, for example, to development, or a regime's commitment to, for example, to engaging with the outside world through commerce, through transactions. I think those you can call the higher law or the fundamental political commitments, which are, I think, the foundation for the stability of institutions and commerce, right? That applies to VIE, to the China comp type stocks, but also to just the transactions, development of market economy in China. So the fundamental political commitments are more important than the tactics of law, which are important, but not as important as the fundamental political commitments. I think that's what I'm trying to do.
Well, we ended right there. We're out of time. Thank you so much, Shitong. For me, this is fascinating. I recommend everybody if they read the paper, if you want to hear more about the legal details or the policy and the theory, it's all there in a great paper, which I think should be widely read and discussed.
Thank you.
Thanks, everybody. Take care.